If you like Pringles as much as I do, you'll be surprised to learn that their former parent company, Procter & Gamble, didn't consider Pringles to be potato chips, not spiritually, not legally, and most importantly, not tax-wise. As expected, the problem started in the UK, where most food is exempt from value-added tax or VAT, unless the Irish have historically depended on it, because potato chips or similar products made from the potato or potato flour don't benefit from this tax exemption, meaning that if Pringles were potato chips, Procter & Gamble would owe 17.5% VAT on every tube, which they very much did not want to. And if they weren't potato chips, then they'd fall into the much friendlier category of whatever the hell Pringles are supposed to be then, but generally food, and thus VAT exempt. So P&G did what any rational corporation would do when faced with millions in taxes, and argued that their potato chips are not really potato chips, and the lawyering here was beautiful. The arguments go that A. Pringles contain less than 50% potato, about 42% to be precise, which according to them is simply not enough potato-ness of course. B. Potatoes do not naturally occur in the shape of a hyperbolic paraboloid, which is true unless the potato has been processed into a potato chip. And C. The other 58% of ingredients which give Pringles their unique taste and texture should be accounted for more, as they make up the majority of this savory snack. And in 2008, a lower UK court agreed, ruling that Pringles were not potato chips for more or less the same reasons as cited by P&G. So for one glorious year, Pringles legally went beyond potatoes, until the Court of Appeal ruined the fun. In 2009, it reversed the decision, pointing out that what matters isn't just the ingredients, but how the product is marketed and consumed. People eat Pringles like potato chips. They are sold as and next to potato chips. They are advertised as potato chips, and everyone calls them potato chips, because they are potato chips. As a result, Procter & Gamble lost, and had to grudgingly offload $116 million in back taxes onto their employees. Now you'd think that this kind of legal hair splitting is reserved only for the finest of corporations, but you'd be wrong, as sometimes it's just regular people moving next to something that's been there for decades and deciding it has to go. Miller v. Jackson. Meet the Millers, a perfectly ordinary family who moved into a house next to a cricket pitch that's been there for roughly 70 years in the village of Leeds, County Durham. And almost immediately after moving in, they started complaining about the noise and more specifically about the cricket balls landing in their garden. After a few attempts to work things out, including raising the fences a bit, the Millers have had enough and sued, arguing that cricket matches caused them nuisance and distress, which prevented them from enjoying their property. And what they wanted was simple. No more cricket on the cricket field that's been there before their house, plus some damages for good measure. At this point, it's safe to assume that the Millers didn't really like cricket, which, fair enough, is cricket. But they were not completely wrong here. You see, home ownership comes with a pretty strong set of rights, including the right to enjoy your property in peace. For this reason, most legal doctrines agree that homeowners can indeed get an injunction against disturbances which would otherwise mess with the right to peaceful ownership. And the High Court of Nottingham applied this doctrine as it granted the Millers the injunction, banning cricket from being played on the club field and awarding them around £150 in damages. But it was not over, you see, as the cricket club appealed the decision, with the case eventually landing under the gavel of Lord Denning, who very much liked cricket. Even though one of the other judges on the panel would have upheld the injunction, Denning asked the right questions and wrote the following masterpiece. In Summertime Village, cricket is the delight of everyone. Nearly every village has its own cricket field, where the young men play and the old men watch. In the village of Leeds, in County Durham, they have their own ground, where they have played these last 70 years. Yet now, after these 70 years, a judge of the High Court has ordered that they must not play there anymore. He has issued an injunction to stop them. He has done so at the instance of a newcomer, who is no lover of cricket. The newcomer bought one of the houses on the edge of the cricket ground. No doubt the open space was a selling point. His wife got so upset about it that they always go out at weekends. After this banger of an intro, Lord Denning acknowledged that homeowners are entitled to enjoy their property, but not to the extent of shutting down a long-established socially valuable activity that existed long before they moved in. Needless to say, the Court of Appeals would overturn the injunction, and the case's Wikipedia page delivers the most exquisite punchline imaginable. Not long after the case, the Millers moved house. Emmett vs. the Hollywood Silver Fox Farm. Sure, the Millers don't sound like your dream neighbors, but neither does Mr. Emmett over here. His neighbors ran the Hollywood Silver Fox Farm, a business dedicated to breeding and then reverse breeding silver foxes for the fur industry. And no, Emmett didn't really have a problem with this, at least not until he fell out with the owners. And once that happened, he put together a plan. You see, silver foxes are extremely nervy animals who can suffer a number of issues when stressed, most notably for our story, miscarriages. And Emmett knew this, which is why he had his son repeatedly fire a gun along the border between his land and the fox farm's breeding pens, specifically to disturb and stress out the foxes during pregnancy. And his plan allegedly worked. causing the foxes to miscarry and with that, financial losses for the fox farm. In court, Emmett would go on to defend his actions by arguing that he had the right to do whatever he wanted on his land, and it was none of his problem that the foxes were particularly too sensitive. The court, on the other hand, ruled that no one has the absolute right to create noises upon his land, because any right granted by law is protected only under the condition that it must not be exercised to deliberately harm or annoy other subjects of the law. Or in other words, you don't get to exercise your rights beyond reasonable limits and then hide behind them once you get sued. That's what some doctrines call an abuse of rights, with a real-life example that I was taught consisting of a neighbor raising and slaughtering pigs in his home in an apartment building. Pearson vs. Chung, or the $1 million pair of pants. Up until this point, the lawsuits were about something substantial. Land, business, sports. This one's about a pair of pants. In 2007, Roy Pearson from Washington DC brought a pair of dirty trousers to a small, family-owned dry cleaner run by Jin and Sue Chung, presumably to get some stains removed at the cost of $10.50. But when Pearson went back to pick up his jizz-free trousers, he was shocked to learn that the Chunks had allegedly lost them and tried to return cheaper, imitation pants instead of his $800 pair. The Chunks denied it and insisted they had returned the correct trousers, and in trying to make the problem go away, offered to settle. What started as an offer for a few $100s eventually turned into $12,000, but Pearson was still unsatisfied. He instead decided to sue the small family business over two signs displayed in the shop, saying satisfaction guaranteed and same-day service. Pearson argued that these signs were an unconditional guarantee, and that any failure, be it real or the one he made up, entitled him to damages. Lots of damages. He demanded a total of $1,500 per defendant, which for some reason also included the Chunks' son, but the formula goes on, because he demanded a total of $4,500 to be paid for each day the signs had allegedly misled him, reaching an estimated 12,000 days. He also claimed emotional distress, legal fees, despite representing himself, and even the cost of a rental car he used to visit another dry cleaner. The grand total? Well, it amounted to an eye-watering $67 million, which Pearson would later lower to a much more reasonable $45 million. If so far it seems like Pearson was just another unemployed lunatic with too much free time on his hands, I guess it's the perfect time to reveal a small detail I intentionally left out until this point. Pearson was a judge. Not like it mattered, as common business slogans are not to be taken at face value and even less as a gateway to limitless contractual liability. A realization that caught Pearson with his pants down, as his claims were swiftly rejected by the court. Not only that, he was ordered to pay the Chunks' legal fees, and, fittingly I might add, a judicial committee would later decline to reappoint him to his position as an administrative law judge, citing, among other things, this very case: Hackard vs. Michael Jordan and Nike. Ordinary people get mistaken for celebrities all the time, but allegedly none do quite as often as Alan Hackard of Portland, Oregon, who sued both Michael Jordan and Nike for a combined $116 million. He claimed that he was getting mistaken for the legendary basketball player so much that it ruined his life, because people would constantly be asking for his autograph or attention wherever he went. According to Hackard, being constantly mistaken for the former Chicago Bulls guard caused him pain and permanent injury, as he could no longer attend religious services, ride public transport, play sports, or eat at restaurants without people confusing him for MJ. No, not the white one. This left Hackard no choice but to seek compensation from Jordan, as well as from Nike for making Michael Jordan too famous, and I could almost see where this was coming from if Hackard wasn't a full 6 inches shorter than Jordan. It also didn't help that Hackard voluntarily kept a shaved head, wore almost exclusively Air Jordans, and rocked an earring similar to MJ's, while never playing professional basketball in the first place. And so, because the case never actually went anywhere, you'll have to decide on your own if they are indistinguishable or not in the comments below. Naruto and Pita vs. Slater. In 2011, wildlife photographer David Slater was taking pictures of crested macaques in Indonesia when one particularly curious monkey picked up his camera and started randomly pressing buttons until he successfully hit the shutter. Out of the resulting photos, one turned out to be genuinely great, well framed, well lit, on par with the Kardashians, and just like the Kardashians, it went viral. The internet being the internet named the monkey Naruto, which is just lovely for all my fellow weebs. It was just one of those internet moments we're all collectively glad happened. But you know how it is, if everyone loves something, someone has to ruin it. In 2015, PETA, nobody's favorite terrorist group, sued Slater on Naruto's behalf, arguing that the monkey was the true author of the photograph and therefore the rightful copyright holder, which entitled it to all the resulting profits. PETA would go on to argue that the photo had very clearly been taken by a monkey, only not the sapiens kind, but the macaque, and leaned heavily into the activism angle by claiming that the money could be used for conservation efforts. On the other side, Slater argued that he owned the camera, set up the conditions, and generally did everything except for physically pressing the shutter. From a legal perspective, animals are treated as property, not much different from your phone, clothes, or, depending on your search history, body pillows. But nevertheless, only humans can be recognized as civil rights holders, including copyright, which should have been the end of it, but not for poor David over here. The case was in fact dismissed, with the judges explaining that A. Copyright law does not apply to animals, but also B. Since the photo wasn't taken by a human either, there was no copyright to be claimed here anyways. Wikimedia and others also treat the image as public domain, which allegedly cost Slater over $10,000 in lost revenue, with PETA having successfully scored another victim. Funnily enough, the same rationale is also being suggested by legal scholars with regard to AI-generated works. As in, since the image/video is made by a machine, there's no copyright to be attributed, which I personally have to agree with. The city of Houston versus Prowler. When a fire broke out in the city of Houston and firefighters showed up, the captain of the crew refused to enter the apartment building, looking visibly frightened at the idea of, well, firefighting. Not only that, if I had a penny for each time he got scared of the very thing he's paid to fight, I'd have 2 pennies, which isn't much, but is still weird that it happened twice. During the second incident in 2006, the captain was reportedly so scared that he couldn't even put his equipment on, let alone give orders, and was ultimately sat down on a bucket by his own subordinates. Following this, the Houston Fire Department reassigned him away from active fire suppression duties and into the training academy, which Prowler was not really happy about. He filed a grievance to be reassigned to active firefighting, and despite the fact that even his own mother testified that the fire department had acted appropriately by removing him after the second incident, the city was still ordered to return Prowler to his previous role. But this is Houston we're talking about, so the city took the decision to the Court of Appeal, at which point Prowler brought up disability discrimination charges against the city, arguing that because of his fear of fires, the city viewed him as mentally disabled, and that this perception could not legally justify his reassignment. If a firefighter afraid of fires claiming that his fear of fires is a disability which cannot lead to him being replaced from active firefighting duties isn't crazy enough, you'd be surprised to learn that the appeals court ruled in favor of Prowler, validating his claims and granting him over $300,000 in attorney's fees. Fortunately though, Houston will Houston till the very end, and brought the case before the Texas Supreme Court. After asking if the captain was even capable of doing his firefighting job in the first place, which believe it or not the city of Houston hadn't even brought up until that point, the court turned the issue to whether Prowler's fear of fires qualified as a disability under the law, and gave us the following analogy. The capacity to play professional basketball is an ability. The rest of us do not suffer from a disability because we cannot play at that level. Fair enough. Then the court went on to say that firefighting is not a major life activity. It is a job requiring highly specialized skills, unique training, and a special disposition. A reluctance to charge into a burning building is not a mental impairment at all. It is the normal human response. As such, the ruling upheld the city's initial decision to keep Prowler away from active firefighting duties because he could not do the job without being a danger to others or himself. The Ghostbusters ruling. If you ever moved into a new house or apartment and your first question was, what if it's haunted? First off, me too brother, me too. And second, that's exactly what Jeff Stambowski had to deal with after purchasing this beautiful property in the village of Nyack, New York. The house known as One Lavetta Place was known to be the home of multiple spirits, and a man by the name of Jeffrey Stambowski, who was unfamiliar with the house's lore, had put down an offer for $650,000 as well as a down payment of $32,000 before discovering the folklore surrounding his future residence. He sued the seller and her real estate agent, demanding to rescind the contract and to recover his down payment, arguing that the seller should have warned him about the haunted status of the home. But unfortunately, the legal doctrine of caveat emptor had something else to say about it. Caveat emptor basically says that it is the buyer's obligation to inspect whatever he's buying, and no defects that could have been discovered during the inspection can lead to a termination of the contract. Moreover, the courts do not typically believe in ghosts, as the facts and evidence brought before the judge need to be, well, factual, and the paranormal is yet to be proven scientifically. Still, Jeff would go on to appeal the initial ruling, and in doing so, get one of the most famous court decisions in US history, known as the Ghostbusters ruling. To learn more about this landmark case and the specific reasons which made the court declare his house to be legally haunted, check out my YouTube video on when the courts believed in ghosts, available right here. Kisses.